Welcome back, and welcome to Focus on Health Law. Here we focus and direct our undivided attention to the laws that are applicable to healthcare. Today's topic will cover a short 15-minute conversation regarding civil sanctions against healthcare fraud. This portion of our show is a presentation of a nationally as well as internationally famous attorney at law. His good name is Mr. Kenneth Haber, whose headquarters are in Boyds, Maryland. The moderator on this set is a renowned attorney, Mr. Ramesh Khurana, from the Khurana Law Firm in Gaithersburg, Maryland.
My name is Ramesh Khurana. I am an attorney at law and I have my office in Gaithersburg. Today I have great privilege to present before you a very good friend of mine whom I have known for the last more than 15 years. He is a very experienced and knowledgeable attorney, especially in regard to healthcare laws. And Mr. Kenneth Haber, he is the former assistant U.S. attorney and a very senior attorney in the Office of Inspector General. Welcome to our studio.
Thank you, Ramesh.
Now today, Ken, I am going to ask you questions about civil sanctions against healthcare fraud. I remember in our last segment, we had spoken at length about the Medicare fraud issues. So today we are focusing on civil sanctions. Now, can you please explain to us what is Social Security Act civil fraud, including Medicare fraud?
Yes. When people think of fraud, they're normally thinking about criminal and criminal prosecution. But the fact of the matter is fraud is basically a spectrum. You know, you can start at one side where you've got waste, and then you got abuse, and you got fraud. And within fraud, you've got civil, and there you got very little evidence that there's intentional wrongdoing. And you can go all the way to the other side of the spectrum, and you can get to criminal, knockout, dead criminal fraud, where the guy goes away for 20 years, and they throw the key away.
Including civil sanctions?
Well,
in some
circumstances,
yeah.
Civil, but when you're talking about the criminal, they're as stiff as the civil, but
Right.
You don't have to go all the way to prove all that in criminal that you have to prove for criminal in order to get some very, very difficult civil sanctions that are imposed upon
So
the
it seems
person.
like you love the word intentional and knowledge, right?
Intentional knowledge, more intent and knowledge that a person has, the more they're going towards that far spectrum where it's criminal.
Right.
When there's less and less intent and knowledge, then it's more towards civil,
Yeah.
Or waste, fraud, abuse, that's commonly discussed. So it's a matter of a spectrum type of situation.
So what is the underlying law about it?
Oh, well, there's a number of different laws. You know, you have the False Claims Act, and you got civil monetary penalties. Now, civil monetary penalties can be imposed administratively, and you never see a United States District Judge. What you see is an administrative law judge who works for the Department of Health and Human Services, and he gets his paycheck from the Department of Health and Human Services, and he sees the same sort of cases day in, day out, and you know, they can sometimes adopt a certain pro-IG perspective. Not saying always, sometimes they don't. I had a case one time where I was on the defense side, and we put up such a good, tough defenses on the civil money penalty when it was first starting that the government realized that the ALJ was not going to be imposing the type of penalties they were looking for, and they asked just to get paid back, and we gratefully were willing to do so. But the point is, you don't see a U.S. District Judge there. After civil monetary penalties go through the whole administrative process, the appeal goes to the United States Court of Appeals, where you have a 3-judge panel, and there's no new evidence coming in. It's all appellate, just reviewing what was done at the lower levels administratively. You know, that could be a civil violation. And At the same time, you have criminal because you have more evidence of intent of fraud here. So the False Claims Act can be civil monetary penalties, could be viewed as a false claims, or you could actually go into U.S. District Court where there's this False Claims Act, and under those circumstances, there are people called relators, whistleblowers that are commonly referred to. And the whistleblowers are people who know about fraud going on to one degree or other. You know, we might not have enough for criminal, but it's fraud civilly, and they can file a claim. The Department of Justice looks at it and decides whether they want to take it or not. If the department decides to take it, then they run with the ball and the relator gets a certain percentage. If the department doesn't want to take it, then the relator has the choice of going forward on their own or dropping it. That's the civil false claims. Now, I was in conversation with some people over at the IG's office, and I suggested to them they should get Congress to pass a provision that their civil monetary penalties can have relators, because of the fact that the Department of Justice just takes a certain percentage, maybe 10% of all the cases that are filed under the False Claims Act, the Department of Justice takes. And there's a lot of cases that just go through the cracks because they don't take them. But the fact of the matter is, some of these cases could be filed with the IG's office in administrative court, and if the relator were to get a percentage of it, you know, there's an incentive to the relator to go to the administrative process. So hopefully that caused a discussion over there. It's supposed to be causing some discussion, and that provision could be then utilized, that incentive could be utilized to have other people coming forth to bring cases where the Department of Justice just doesn't have enough manpower to cover all the cases.
Makes sense. Beautifully explained, Ken. Okay. Now, you did touch upon false claims issue. Now, can you please explain what are the False Claims Act violations?
Well, anytime that there is a claim for money, if there's a misrepresentation by whoever's presenting it, that would be considered a false claim. There can be conspiracy under the False Claims Act. There can be implied certifications where there's actually not a statement that's false. Let's say you're applying for payment for a widget, and the contract had certain requirements in it. Let's say the Defense Department contract, and you're wanting your money for widgets. You're presenting it. Well, you're certifying that you complied with all the contract provisions. You're implicitly or explicitly certifying that you complied with all the contract provisions to make those widgets. And it's a widget, but it didn't go through the process it was supposed to go through. It didn't have all the testing procedures that were necessary to make sure it was a widget that would withstand the punishment of battle out on our battlefields where our servicemen are, that they need to make sure their widgets shoot when the widgets need to shoot.
Right.
So that would be a false claim because you didn't go through the testing procedure, so it can be that type of falsity too.
Oh, wonderful, wonderful. Now let's move on. Let me ask you another question. What are civil monetary penalty violations?
Those currently are the ones where are being handled administratively by the Inspector General's office within the Department of Health and Human Services, and other agencies may have civil monetary penalties of their own for their particular agency, but the IG's office...
This is handled by OIG office?
This is handled by the OIG for Medicare, and they file the claims against people. They see if they can negotiate with them. And if they can't negotiate, they'll file the claim against them in the administrative court. And they don't currently have provisions for relators. Who knows, maybe they will. But the fact of the matter is the penalties can be just as stiff. They can have 3 times the damages, the amount of the claim that is, plus they can have $10,000 for each claim. And also, they can ask for exclusion of the individual because of the findings against them. They can impose an exclusion against the individual because of the findings against them. And that puts the person out of business, the Medicare business and all the other government health care business. And when they're excluded, none of the private carriers want to deal with them either.
Okay. Now, in response to my question, Ken, you just used the term relator. Now, who is a relator under the False Claims Act? Can you please elucidate?
Sure. A relator is an individual who knows of, and it's not in the public record. There's a big litigation point if it's in the public record, whether it is or isn't, but who knows of it on his own, an original source of wrongdoing by somebody, and comes to an attorney such as myself or somebody else with the experience and says, I know of this person making false claims against the government, and they're getting millions of dollars from the government, and it's fraudulent, and you know, I'd like to report them to the government. How can I best do it? I said, well, you can take the time to do it, you know, and help us put together a case, and we can file it, and if the government takes the case, then you can get a certain percentage of what the government's take is in it.
So what you are saying is that this is government's discretion based upon their evaluation, whether they like to accept the case or not.
Absolutely, and
So
they take
what's the percentage of accepting these types of
about
cases?
10%.
Oh, just 10%.
About 10%.
So it has to be a strong case.
It has to be a strong case. Department of Justice Civil Division is not interested in, you know, weak cases because they have so many cases coming at them.
So how does it work? And do you actually prepare the complaint and file it with the U.S. District Court, or you just show it to the OIG office?
You file it under seal.
Or you file it under
And it
seal.
goes to the Department of Justice, not to the OIG. So it's under seal.
Okay.
And I had one case one time where I get a call from an attorney for the hospital. And they said, we saw that you just filed a key tam against our client. It was on the PACER system, which is the government system for cases in the clerk's office. And I said, excuse me, what? He says, yeah, it's on the PACER system. You know, we want to know about this. And, you know, we represent Hospital XYZ. I says, well, I cannot admit nor deny the existence of this. I got off the phone with the person. I called up the U.S. Attorney's office, and I said, hey, something went wrong with the clerk's office. And sure enough, the clerk got the court order saying that it was supposed to be under seal, but they goofed and didn't file it under seal. If it's under seal, no one sees it. And that was a rare goof. You know, that just doesn't normally happen, and no one sees it. Department of Justice then has the opportunity of reviewing it, making a decision whether they want to take it or not, and if they take it, then they do the legwork normally, although sometimes you do some legwork as the attorney for the relator. And you've done a lot of legwork already because you put together the complaint, and if you're smart and you know what you're doing, you actually put together a prosecutive memorandum setting out who the witnesses are, setting out what the evidence you have, et cetera, the contact of the witnesses, any evidence that you have, you make it all a package. So, you know, it's the type of situation where, you know, you're making it usually user-friendly for the Department of Justice when they're making their decision.
So, Ken, I have observed that you have been using two buzzwords very frequently, like he knew or should have known. I think it becomes very important if we discuss the meaning of these two words in the context of Medicare fraud.
Sure. Knew is where you can actually prove somebody knew, i.e. that you've got a witness saying, I told this person that they're not supposed to do this, and yet they did it anyways. So there's some good strong evidence that they knew. Hey, I gave them this handout that said that you can't file this way, and yet they filed it. They knew. Now, should have known can be that it's in the public arena, that it's been published by the government, and people are assumed by the government to know it's out there, that it's published on the Medicare website, that it's published in the learning and training bulletins that the government puts out, and they expect you to keep posted. If you're asking for government money, the government's expecting you to stay on top of what you can and can't do. And if you don't, then they say you should have known.
Okay. Now, we have been talking about basically imposition of civil monetary penalties. Can you just briefly tell, we are left with just half minute. Now, what's the mechanism involved here?
A civil monetary penalty is one where the Inspector General's office can impose similar punishments like the False Claims Act, but they do it administratively, and it can be just as costly for the individual or more so.
Wonderful. Thank you so much, Ken.
My pleasure.
No, it has been a great pleasure interacting with you today in this session, and I'm sure our audience has found these explanations given by Ken Haber, who has been in this field for the last more than 3 decades, I believe. And I must thank you again for coming to our studio. Hopefully, we will have you again here.
Thank you.
Thank you.